Welcome to this First Nations Child and Family Services and Jordan's Principle Settlement Claim Form walkthrough video. This video was created to help guide you step by step as you fill out the claim form as the representative of a removed child who has died, or Claim Form B. If you are submitting a claim form for yourself, or if you are the representative of a removed child who is alive and is a person under disability, you need to fill out Claim Form A, not this claim form. Before we get started, there are a couple of things you should know about. The deceased person may be eligible as both a removed child and a caregiving parent or caregiving grandparent. If that is the case, just know you'll need to fill out separate forms for each of those classes. Filling out a claim form can be an emotional experience, bringing up a lot of memories. You don't have to fill it out all at one time. You can take breaks and come back to things as you feel ready. If you need additional help, you can call the administrator. They can answer your questions or connect you with a claims helper. And if you feel you need wellness or mental health support, you can reach out to someone through these free services, which are available 24 hours a day. All right, let's start your claim form. This is Claim Form B. This is the form you will need to submit for a removed child who has died. Let's start by defining who may be eligible as a removed child under the settlement. A removed child is someone who is a First Nations person and was removed from their home as a child, someone under the age of majority, while the child or their caregiving parents or caregiving grandparents were ordinarily resident on reserve in Canada or anywhere in the Yukon. This means the child's parent or grandparent were living on reserve most of the year. If this doesn't describe the experience of the person you are submitting the claim for, or you want more information about the various definitions, visit fnchildclaims.ca. The age of majority varies by province and territory. In some cases, it is 18, and in other areas, it is 19. You will need to check to make sure which applies to the removed child. A deceased removed child is someone who was removed from their home by child welfare authorities or voluntarily placed into care between April 1, 1991 and March 31, 2022, and died on or after April 1, 1991. There are some other important eligibility requirements to meet under the terms of the settlement. The removed child's placement must have been funded by Indigenous Services Canada. Removals from the Northwest Territories and Nunavut are not covered under this settlement agreement. The removed child may have lived in the Northwest Territories or Nunavut later in their life, but will not be eligible if they were living in those areas when they were removed. To learn more about eligibility requirements, you can use the Eligibility Information tool at fnchildclaims.ca or call the administrator. When it comes to the deadline to submit a claim for a removed child who died on or before March 10, 2025, you have 3 years from the date the claims period opens to send this claim to the administrator. It's important to know that it doesn't matter how old the person was when they died. If they died before March 10, 2025, then you need to submit this claim by March 10, 2028. If the removed child died after March 10, 2025, while under the age of majority, the deadline to submit this form is 3 years after the date the person passed away. As you can see, there are different deadlines depending on the situation. If you have any questions, reach out to the administrator to make sure you don't miss a deadline. Now let's talk about your role as a representative of the removed child who has died, who under the settlement is a deceased removed child. To qualify as a representative of a deceased removed child, you need to be an individual who is legally appointed to represent the estate of the deceased removed child. Or you are the highest priority living heir of the deceased removed child if the removed child died without a grant of authority. We'll explain what a grant of authority and highest priority living heir are a bit later in the video. For now, we'll start with filling out the claim form. The form officially starts on page 2. Part 1 is for information about the deceased removed child. Part 2 is contact information for you, the representative. This includes your address and other contact information for the administrator to reach you. Part 3 provides instructions on the valid identification for the deceased removed child you will need to submit with the claim. Part 4 is signed and dated by the person completing the claim form, in this case, you as the representative. After that, you would complete either Part 5 or Part 6. Part 5 is completed if there is a grant of authority in place and you are named as the executor or administrator of the estate. Part 6 is completed if there is no grant of authority in place and you are an heir of the deceased removed child. Part 1 is where you fill in basic information about the deceased removed child, like their name, birth name if it's different, and date of birth. Enter the date of birth using the numbers for the month, day, and year the removed child was born, in that order. Make sure the name and date of birth match the ID you will provide in Part 3. If you have an Indian registration number and social insurance number for the removed child, you can add them too. You can submit without this, but having this information may help the administrator process the claim. Part 2 is where you provide your contact information as the representative. This is where you include your name, your mailing address, and mobile, home, and office phone numbers, including the extension if there is one. Providing these numbers as well as an email address will help the administrator contact you, especially if you move. If you are a representative who has been appointed to represent the deceased removed child as part of your job, for example, a public guardian or trustee, you need to provide the name of the organization you work for. Your contact information is even more important if your mailing address listed here is temporary. For example, if you are staying in a correctional or medical facility or a public place like a hotel or friendship center. In some cases, you may be staying with someone and are using their address. If this describes your situation, please be sure to add the name of the place where you're staying. Even if you're staying with a family member, please add their name to help the administrator get in touch with you if it's needed. And if your contact information changes, please call the administrator right away. This is important because if the administrator can't reach you, there could be delays in processing your claim and receiving your compensation. Part 3 of the form asks you to attach one piece of government identification for the deceased removed child. Accepted ID includes anything on this list. While you only need one piece of ID, it is a good idea to provide multiple pieces to make it easier to confirm the deceased removed child's identity. You can find a full list of accepted ID at fnchildclaims.ca/identification. Attach a photocopy, scan, or a photo of the identification. Never send the originals. Now we'll move to part 4, which is a privacy release and acknowledgement. Your privacy is important, and the administrator is committed to protecting the information you provide. That said, processing a claim may require others to be involved, such as the Government of Canada, Class Counsel, third-party assessor, the Settlement Implementation Committee, claims helpers, and child welfare authorities. In cases with competing claims or multiple people claiming to represent the deceased removed child, information may be shared with those representatives, if required under the claims process. It is important that you read this page carefully and make sure you are comfortable with what it says. By signing Part 4, you are acknowledging and agreeing that, in certain circumstances, the administrator or child welfare authorities may need to share your information to process your claim. You are also acknowledging that the administrator, claims helpers, and third-party assessors don't represent Canada or provide legal advice, and that the information you are providing is true to the best of your knowledge. You also understand you might be asked for additional information needed to process your claim. It is very important to sign and date your claim form. An unsigned or undated form will lead to delays in the administrator's ability to review your claim. The form needs to be signed. If you do have questions, you can contact the administrator at no cost. What you fill out next depends on your role as representative. If a grant of authority is in place and you are named the executor or administrator of the estate, you will fill out Part 5. Complete Part 6 if there is no grant of authority in place. We will start with Part 5. A grant of authority is a document that names you the estate executor or estate administrator. It's your proof that you have the legal authority to receive compensation on behalf of the estate of the deceased removed child if they are eligible. This can be a will or notarial will in Quebec, a grant of probate issued by a provincial or territorial court order, or a grant of administration letter issued by the Government of Canada, for example, from Indigenous and Northern Affairs Canada, Indigenous Services Canada, or Crown Indigenous Relations and Northern Affairs Canada. If that describes you and your role, you'll need to provide the following information with the completed claim form: a copy of the grant of authority document that shows your appointment as representative, executor, or administrator of the deceased removed child's estate, the deceased removed child's date of death, and related evidence that might include a death certificate, a funeral director's statement of death, or a burial certificate, and a photocopy, scan, or photo of your own government ID as the representative. Here is a list of acceptable identification. ID is required, photo ID is preferred, and please ensure your name on the ID matches the name you provided in Part 2 of this claim form. You should also know that when a grant of authority is in place, payments will be made payable to the estate of the name of the eligible deceased removed child and sent to you as the representative, unless the grant of authority document says otherwise. If there is no grant of authority, you can still submit a claim as a family member of the deceased removed child, specifically as the highest priority living heir. The highest priority living heir could be a spouse, child, grandchild, parent, sibling, or grandparent of the deceased removed child in that order. This is outlined in the settlement agreement. If that describes you, then you need to fill out Part 6 of the claim form. There are 2 steps. First, you are asked to confirm that to the best of your knowledge, there is no grant of authority in place for this deceased removed child. This means they died without a will and no executor, administrator, or trustee has been appointed by the court or by the Government of Canada. If this is true, check this box. If this is not true, you may not be eligible to complete this form. Call the administrator. If you've confirmed that there is no grant of authority in place, you will need to identify how you are related to the deceased removed child. Check the box that represents your relationship. For example, if you are the brother of the deceased removed child, you would check the box next to siblings. Then, and only if it applies, fill in the number and full names of the other living family members in each of the categories. Step 2 involves providing documents that show you are related to the deceased removed child. Starting with your Indian registration number, if you have it, and your date of birth. The administrator will attempt to confirm your relationship if you are First Nations and have a biological relationship to the deceased removed child. If you are not First Nations or you're not biologically related to the deceased removed child, then you will need to provide evidence of your relationship using documents like a long-form birth certificate that names the biological parents and children, verifiable provincial, territorial, or custom adoption papers, or marriage documents, or evidence of common law relationship. If you have other documents, please name them. You will then have to provide evidence of the deceased removed child's death and the date of their death. This might be a death certificate, a funeral director's statement of death, or a burial certificate. And as the representative, you'll have to attach a photocopy, scan, or photo of your government identification, ideally photo identification. Please ensure that your name on the ID matches the name you provided in Part 2 of this claim form. Once again, please remember to never send original documents, only copies. And it's important to note that compensation for an eligible deceased removed child class member where no grant of authority is in place will be made payable in the name of the approved and eligible highest priority living heir. If there is more than one approved and eligible highest priority living heir, compensation may be split equally amongst those heirs. Okay, you've filled out all your information and gathered all your support materials. Now, how do you submit everything? There are 4 ways. The first is online, which is the fastest way to get your claim in. You do this by visiting the online portal at portal.fnchildclaims.ca. You'll create an account and then be directed to submit all claim form information online. Once you have completed all your information, you'll upload a copy of your identification and other documents and submit. The second way is to fill out the PDF claim form online and then either add your digital signature or print it to add your signature and date. You can also print the claim form and complete it by hand. Either way, don't forget to sign and date your claim form at Part 4. After you've completed it, you can sign it and scan it, along with your identification and other documents. You can then email it to claims@admin.fnchildclaims.ca. You can also fax it to 1-416-815-2723. And of course, you can always mail everything to Settlement Administrator, P.O. Box 2500, Station, Maine, Newmarket, Ontario, L3Y 0H9. Please do not courier your claim forms because the administrator cannot accept courier deliveries. The important things are to fill out your claim form completely, include copies of your ID or other required documents, sign and date your claim form, and send everything in before the deadline, which depends on how old the deceased removed child was when the claim period opened and their date of death. Remember, you don't have to do this by yourself if you don't want to. You can call the administrator with questions, and if you need more support, they can connect you to a claims helper who can provide one-on-one assistance to help you complete your claim form. If you need wellness and mental health support at any time, reach out to Hope for Wellness or the Kids Help phone line. We hope this has been helpful and that you have the information you need to submit your claim or know where to go if you need additional support.